Professor Hill, and again, Professor Max Mellman and Jesse Hill helped us do the analysis in bad medicine. Jesse Hill's going to say a few comments, and then hopefully both of them will be available in the question and answer period, so we can so you can hear more from them at that time. So, Professor Hill, would you like to say a few words?
Actually, I'm going to start, Janetta.
Okay, thank you, Max.
And I'm going to turn it over to Jesse, because I'm just going to reiterate some of the points that Janetta made about how broad and poorly drafted this constitutional amendment is. And as she said, it looks like at least most of that was intentional. So, for example, one of the provisions says you can't force any, if it were to be adopted, would say you can't force anybody to participate in a healthcare system. But as my colleague Jesse will explain in a minute, the term healthcare system is defined in this in this amendment so broadly that it would almost be unlimited in terms of what it would prohibit. And another provision says you can't force anybody. You can't punish anybody for buying or selling health care or health insurance. So think about that. Anybody could sell anything in this state as long as it was health care or they called it health care. Think about how overbroad that is. Now, there is indeed a provision in this proposal which would attempt to sort of limit the scope of it. And it says, for example, that the law wouldn't affect any other law that was in effect before March 2010. But the important thing is that it would affect any law or any change in any law that was made after that. And in addition, there's a provision that says that it wouldn't affect laws that deter fraud or punish wrongdoing in the healthcare system. But those terms are not defined, and as they would be commonly understood and interpreted by courts, who would, of course, have to do the heavy lifting here in terms of figuring out what this meant, these would allow this amendment to interfere with all sorts of laws and regulations that are designed to protect the health and welfare of the citizens of the state. And so my colleague, Professor Hill, will give you some more specific examples of the kinds of things that would be jeopardized by this ballot issue.
Thanks. So, yeah, as Professor Mellman and as Janetta said, the language is so broad and so sloppily written, really, that it's likely to lead to enormous uncertainty, not to mention a substantial amount of litigation if this provision were adopted. And just to give some examples, Max mentioned that the term healthcare system is so broadly defined and includes any sort of information gathering, information data management concerning healthcare, virtually anything connected with healthcare, so that the sorts of things that might be jeopardized by an amendment like this are mandatory participation in workers' compensation systems, immunization reporting, mandatory immunizations, infectious disease reporting, COBRA, and as Janetta mentioned, the recent pill mill legislation, for example, with its reporting requirements would also be nullified, certainly, by this law. It's particularly troubling, not just because of the amount of sort of core functions of government that would be affected by this amendment, and because of the uncertainty, but the very idea of freezing in time something having to do with healthcare, saying that, well, we're going to hold all the laws at where they stood in March of 2010. Seems like a terrible idea in general, but it's a particularly bad idea in the healthcare industry where things are changing so rapidly. If you think about, for example, the infectious disease reporting or the vaccination laws that we have in place and reporting laws, if some new strain of some virus were to come along, as they often do, we would not have the tools within our laws to require disease tracking, for example. Also, court orders that are come into effect after 2010 would presumably also be affected by this law. So any court ordering, for example, payment of health care for a child in the context of a child support or custody order or a neglect proceeding, those court orders would arguably be affected by this law. And finally, the provision that Max just mentioned for exempting laws that are aimed at wrongdoing, deterring fraud or punishing wrongdoing in the healthcare industry, that term wrongdoing is not anywhere defined in the law. It's not a legal term of art. It's not at all obvious what that means. So even the scope of the exception is not apparent. It is going to generate enormous uncertainty. And what's more, it doesn't appear that that exception for laws aimed at deterring fraud or punishing wrongdoing would have any effect, would have the effect of saving administrative regulations. It seems to not save administrative rules or regulations the way the law is written. So those Ohio administrative rules, which are updated on a regular basis, again, precisely to keep pace with the changing conditions, the various agencies that promulgate those rules would have their hands tied with respect to making any significant changes pertaining to healthcare after the passage, if this law were to pass.